Good morning and welcome from the Senior Law Day Collaborative. My name is Melinda Bellis and I'm an attorney in charge at Legal Services of the Hudson Valley. I'm also a co-chair of the Senior Law Day Collaborative. I share this role with Elena Falcone from the Westchester Library System and Sarah Steckler of Warsaw Burstein. We are also ably assisted today by Bruce Siegel of Marketing Sense. You've joined us today to learn about using the new power of attorney form for New York. We'll do that in just a few moments, but first, let me tell you a little bit about the collaborative and the resources available to you. The collaborative is composed of more than 150 professionals who are all eager to bring authoritative information on legal, financial, and health topics to our county's older adults. We make available educational workshops throughout the year, as well as brief one-on-one consultations with collaborative professionals. You can connect with our resources and services through our website, seniorlawday.info. The site is a resource for information on legal and financial topics addressed by the collaborative. In fact, you can go there to watch the video recordings of prior webinars, access printed reference materials such as our annual, updated, and excellent elder law Q&A. And you can send us your questions on any topic of concern to older adults. Just look for the Ask Us button on the site. Send us your contact information and a rough outline of your question. We will work promptly to connect you with the needed expertise. And now a few points about the format in which we're working today. This Zoom video conferencing event is being recorded with the aim of posting the recording to the Senior Law Day site. You as participants are muted. You can, however, ask questions via the Q&A box on the bottom of your Zoom window. We may not be able to answer all the questions that are posted, but unless you choose to ask anonymously, we'll work to follow up via email. You might also save your question for that Ask Us button on the seniorlawday.info website. And now I'll turn this presentation over to today's presenter, Deepankar Mukerji, who is an attorney and chair of the Elder Law and Special Needs section of the New York State Bar Association. Deep?
Good morning, everybody. I hope we're all doing well, staying cool today. It's still a hot day, but hopefully it'll get better tomorrow. So yes, the power of attorney is a reality. It is the new power of attorney form took effect on June 13th, and it is now the form to use. The old form should no longer be used. So I'm going to walk you through the new form. We're going to talk about the various elements, various pieces, and the various modifications that could be made to the form. Okay, so let's talk about the new form. I mean, well, first of all, let's talk about what is the power of attorney. So the power of attorney, I just want to touch the background a little bit here. So we're all familiar with this. The power of attorney is an instrument that allows a principal to appoint an agent to perform various functions for them, generally financial. It does not confer healthcare decision-making powers. So in the old days, but this is pre 2010, we used to call it an attorney and in fact. So the attorney in fact, was you appointed an attorney in fact. That language has been gone for approximately 10 years. We call it a principal and an agent. So you're the principal, you're signing the power of attorney, you're giving power to an agent to act for you. They have to be executed by while you're competent. You have to know what you're doing when you sign it, and they will survive incapacity. And that's why the term durable is used for this power of attorney. Although I have to tell you that on the form, you won't see it say durable power of attorney. That language is kind of old too. It doesn't say on the title, it doesn't say durable power of attorney, but it is, because there is a provision that says that it will survive incapacity. So that's how we know that it's a durable power of attorney. All right. Okay. So the first thing that you will see on the form is there is a caution to the principal. All right, and this is part of the statute. There's a bunch of language there that tells you this is an important document and this is what it does. And it's kind of similar to what I just said. And we're going to take a look. Let's take a quick look at it. I'm not going to really go through it, but here is a caution to the principal. It says that you're going to choose your agent and you're going to give your agent a lot of power. So you got to be, you have to be careful. You have to make sure that you trust your agent. It also says that you can revoke or terminate the power of attorney whenever you want. So that keep that in mind. That if you have some kind of a falling out with your agent, or your agent is not doing the job, you can always revoke this power of attorney. Okay. So there we go. This is the required language. If this language is not there, we do not have a statutory form. This is required. This caution to the principal language. All right. So what's the first thing that you do? The first thing you do is you write, you have your name and address, and then you appoint. You could appoint 1, 2. You could appoint more people. You could actually appoint like 3 or 4 people if you wanted, and we just have to make room on the form for it. But it's there. 2 slots are there on the actual like statutory form. So you appoint an agent, and then very important on the bottom here it says my agents may act separately. That box must be initialed. All right, if you want your agents to act separately. Otherwise, say you appoint 4 agents and you don't initial that box, then every document, every action that your agent undertakes is going to be require like 4 signatures. So it will get really crazy and it will be unworkable. So you want to sometimes people want the agents to act together. Sometimes when there's like 1 or 2, but if there's more, then it's definitely going to become unworkable. So there you go. That box has to be initialed. You put your name in, you put the agent's name in, and then you have to consider whether you need to initial the box about whether they can act separately. All right. The next part of the power of attorney is you could designate a successor, a backup. All right, somebody who can step in if your agent resigns or something happens to the agent can't act anymore. And that's the only time that successor agents can need to step in. All right, they don't act at the same time as the agent. They only act when the agent is unable to act. So if you want a successor agent, you initial in that box. And you could also provide for specific succession rules. I mean, and there's a lot of different things that people can do in terms of succession. I mean, you could say that, well, if my daughter's the agent, and if she's unable to act, then my granddaughter, all right. And if you had like 2 agents, you could specify which one replaces which. So that's why you might want to have some rules in there. And there's a special section that allows for specific succession rules. Okay. So what are the powers? What are the powers that you gave to, that you're giving to your agent? Okay. So here they all are. I mean, these are the ones that are in the statute, and they're right there. They're right on the form. And I know that at the end of my presentation, I think that the same question has been answered, but I know people are asking about, where can you get the form? And I have instructions on that. One is either you go to the laws of New York, to general obligations law, and you can pull it up. It's section 5-15 something, 1513, I believe. And so that form is right there in this, but it's 5-1500, and then that's where the power of attorney law starts. So you could go there, or you could buy it off the New York State Bar Association website. It's $35, including the modifications. But so it's $35 if you wanted it. It comes as a Word form, and I'm sure legal forms, the legal form companies such as Bloomberg and everything. They're also selling their own forms. So everybody's got forms, but you have to kind of go out and look for it. Okay, so these are the various powers. Real estate transactions, chattel and goods transactions, bond, share, commodities, banking transactions, business operating transactions, insurance transactions, state transactions. We're still going to go. And we got claims and litigation, personal and family maintenance, benefits from government programs, financial matters, retirement benefits, tax matters, all other matters, which is, catch-all. I don't know what it really means, but and then full and unqualified authority to my agent to delegate. Now, so what you can do is you could pick these powers. You could go through and initial the powers that you want to confer on your agent. All right, what are the powers that you want to give to your agent? You could say, well, I don't want to give him I don't want to give my agent the right to do my taxes, so I'm not going to initial that box. All right. What we tend to do, what most attorneys tend to do, unless it's warranted, unless we know otherwise, is that we will put all those above powers in section P at the bottom here. Section P says each of the matters identified by the following letters, and then we just go through them: A, B, C, D, E, and you cannot. Apparently, this is this is a technicality, but you cannot just say A through O. You cannot say that. Each of the powers identified as A through O. You have to identify each particular letter. And you could take some stuff off if you wanted to. So it might be A, C, D, something like that. Anyway, that's box P. So if you have all of the above in box P, then you don't have to initial all these different boxes. All right. And that is the standard form. I have a hand up. I don't know if can we maybe wait till after the presentation, or is that?
Deep, I know one just asked in the Q&A if you have an old POA, do you need to substitute a form? I know you'll be discussing that.
Yeah, I think let's hold off on some of those questions until I get through the presentation, and then I'm happy to talk about to address your questions. Okay, thank you. All right, so that was the basic thing. We have the grant of authority. We appointed an agent. We gave the agent work to do. We gave the agent some things to do. Then the next box has to do with gift transactions. Okay. Now, if you just use the standard powers, then there's you have gifting power to make gifts in the aggregate of $5,000. All right. Now this is a kind of a big change from the old form. The old form said $500. Okay, so the legislature increased that amount to $5,000. So now you can make gifts, and this is in the aggregate. That means total to everybody. Okay, you can make gifts of $5,000. However, if you want to give more than that, if you have a gift giving pattern, or you intend to do various things like establish a trust, then which has a gift element to it. All right, establishing a trust always, there's part of it will be a gift. So in order to do that, you got to make sure that this box is initialed. This is box G. And it says, I grant my agent authority to make gifts in accordance with the terms and conditions of the modifications. All right. So not only do you have to initial this box, but you got to put you got to put it in the modifications. What kinds of gifts can your agent make? All right. And that needs to be specified. The manner of gifting and so that again, that's in the law. So you have to, this would have to go into the modification section, which we're going to talk about, but I think I'm going to talk about it later. But just keep that in mind that it's not good enough just to initial this box. You have to put something in the modification section. So you got to tailor the form to your needs. And so these are just some of the other provisions that are on the form. There's this ability to designate a monitor, which people thought that would be a good fraud prevention piece, where you could designate a third party who had the ability to review accounts and do things, to make sure that the agent is doing their job. So that's what a monitor is. However, there was no provision for payment of the monitor, and it's a little bit murky about, like, what exactly the powers of the monitor are, and what are the potential liabilities that a monitor might have. Like, what if the monitor doesn't do doesn't actually oversee the transactions? Well, so we don't use it a whole lot. If people really want it, we can definitely put it in. So I think some people, some attorneys will use it. I really don't. I don't think I've had a single power of attorney where I've used a monitor. Okay. And then, all right, section J is compensation of the agent. Compensation, you can provide for the agent to get paid for the work that they're doing. You don't have to. You don't have to do this, and you don't have to initial that box. But if you feel that your agent is going to be doing a lot of work and they might want to get paid, you can put it in. Then you can define how they get paid in the modifications. So let's say you decide, well, I want my agent to get paid $15 an hour. It has to go in the modifications. All right. Or if you just say, well, I want my agent to get paid in accordance with trust law, which that's a common provision that, for commissions of trustees and things like that. So you can put that in, but that all has to be in the modifications. All right. So I just put, and then there's this acceptance by third parties. All right. You indemnify, as principal, you're indemnifying third parties, such as a bank, from any damages that they will, that they incur, any losses that they incur by relying on this power of attorney. You're telling people this is a good power of attorney, it's valid, and then there's also this the onus is on you to, if you revoke it, or it's actually on your agent. If the power of attorney is revoked, they have to be notified. All right, they should be notified. If you've used the power of attorney to open a bank account and then you revoke the power of attorney, the bank has to know. They have to know that it's been revoked and there's a new person. So here's the standard termination. It continues until revoked. All right, and so there's nothing that really points to revocation of a prior power of attorneys. That's going to be modifications, and I'm going to get to that in a little bit. Okay, so that's your basic form. At the end, you got there's a signature and acknowledgement. Okay. Also, it has to be signed before two witnesses. Okay. You have to have two witnesses. The notary can be one. So the person who's going to notarize your signature, that you're acknowledging your signature to, it can be one witness. But you do not use an agent, probably not a spouse of an agent either. You got to be careful as to who it can be a witness. You want a person who is disinterested, who's not going to stand to gain from this execution of this power of attorney. I put a little thing in about electronic signature. There's a new law that was passed by the state legislature. I think it was recently signed by the governor regarding electronic signatures. And that's like DocuSign or something. We generally don't expect them to be, technically they may be used on a power of attorney, but the problem is that electronic signatures are not valid for recording documents. All right, so if they need to be recorded, for instance, in connection with the transfer of real property, then it could not have an electronic signature. So there's something, we actually writing the governor about this. We wanted to sort of just be clarified that in general, electronic signatures, can't be used for certain of these documents. A lot of people, over the pandemic, the governor issued a bunch of executive orders regarding remote witnessing and notarization, where you could use a video device like Zoom or something like that in order to execute a document. So you could have the notary could be remote, the notary could be in another location, but as long as you could video conference and you could see each other, and the notary could see what you were doing, and you could tell the notary what you were doing, and then you could electronically send the document to the notary, they could do a remote notarization. And I think a lot of people have been using this over the pandemic. I think that it's not going to be extended. I think that the legislature is considering some laws to perhaps provide for remote notarization, but we haven't seen it yet. I would kind of shy away from remote notarization at this point because the public health emergency declaration is over. I'm not really solid on whether a remote notarization should be used after the end of the public health emergency, because those governor's executive orders were there, they were there as a emergency measures. All right, they were there, for public health reasons, and once he declared the emergency over, I don't know. I think that there may be some clarification coming from the governor on this, but I'd be very careful about using remote notarization until we actually have a law from the state legislature on it. Okay, so that's basically the form we got.
Quick question. I'm sorry.
Sure.
Someone's asking if the second witness can be the office help from the notary office.
Sure. If it's a dissent, yeah, we all use people in the office, people use the secretaries and receptionists and whoever, it has to be a person over the age of 18, and that's pretty much it. So it can be anybody. It should be a disinterested person. Somebody does not stand to gain. But yes, using different people in an office, people in a law office or a notary's office are fine, as long as there's two of them. Okay. All right. The power of attorney has to be signed and accepted by the agent, and again, the agent's signature has to be notarized. So it's not valid. The form is not valid until the agent signs. All right, you can appoint an agent, but the agent has to accept the responsibility for being an agent. All right, they have to accept that responsibility. And so I think this was a question that was asked. I think I did see that, whether they all had to sign at the same time, and the answer is no. The agent could sign later, but the form is not valid until that agent signs. So do successor agents have to sign? Successor agents do not have to sign, okay, at the time. They can, in fact, I usually don't have successor agents sign until they're needed, all right? At the time when they actually need to step in and do the job, that's when a successor agent will sign. And again, their signature has to be notarized. So that's the form, okay? We have, like I said, we talked about revocation, but the revocation and gift provisions have to be in the modification section, all right? So now we're going to talk about the various modifications that you can do. And the State Bar Association they have standard modifications. There are standard, there are suggested modifications that they want, that they want you to pick and choose which ones work for you, which ones you want. And so they will all, they all go into the modification section. Now, one of the burning questions regarding this that's been come up is that people have asked about is, on the old form, people used to always have like initials. You know, you'd have to initial each modification. It's not really strictly required, and it's not required on the new form either. So you can put all these provisions in, but they're you don't have to do you don't have to have each one initialed. All right, you can put them all in; they'll all be operative. You could, if you want, have. I mean, and this is an attorney thing. You know, it's a drafting thing. You know, do you have little boxes for people to initial or not? Now, so if you the reason I'm telling you this is because you may see this both ways. It's not strictly required under the law for there to be boxes in the modification section for you to initial. So let's just go through some of these. There's a guardian provision, and these are all from the State Bar Association's form. The State Bar Association, you know, the elder law section, we worked very hard on creating the new law and creating the new form. So a lot of this comes from the people who actually authored the law. So the first thing is a guardian provision. It's not a it is not required, but it's something, and it's not a guarantee that a guardian your choice of guardian will be appointed. But you have this provision that says that if I should ever need a guardian, a court-appointed guardian, then I want so-and-so. I want my agent to serve as my guardian. Okay, so you can nominate somebody here, and you can nominate a successor. There is, again, no guarantee that the court is going to accept that, although, you know, it certainly serves as a strong statement on your side that this is who you want to be the guardian. But, you know, ultimately, it's up to the judge. So the judge could throw that out if they wanted and appoint somebody else. And so I just want you to know that. But this is a provision of the law that allows you to say who you want to be your guardian. Okay, so then gifting provisions. Remember, I said this is important because if you wrote that box in that said you want your agent to be able to do gifting, then you need to specify how it's done. So here is some gifting provisions that I allow them to. You know, this is my spouse, children. So the first one is a standard exclusion amount. That's the IRS amount, which I believe is still $15,000 per person per year. That's the standard exclusion amount for estate tax. You know, we don't really pay that much attention to it since the estate tax is now $11 million, the total exclusion, but it is part of your unified credit. Okay, so if you wanted to reduce your estate, if you had an estate that was going to verge on $11 million or so, and you wanted to reduce it, you can reduce it by using the federal gift tax exclusion. And remember, it's not an exemption for Medicaid. It's not you know, it's only an exclusion for federal gift tax purposes. Meaning, if you have an estate over $11 million, then it may be worthwhile to reduce your estate using this method of giving $15,000 a year. So that's one provision that you could use, is just say, well, I want to be able to give the $15,000 a year per person, and that would be fine. And that's all I want my agent to do in terms of gifting. All right. So the other thing you could do, though, is specify all these gifts. You could specify dollar amounts. You could you could limit it to a certain person or a gift or a class. You could name charities in here. You say, I want to be able to keep giving gifts to the World Wildlife Fund, something like that. Okay, that could be in here too. That could be in the modifications where you say, yeah, just that's the only person I really want you to give gifts to. I've been supporting this charity for a long time. Or it could be my church, right? It could be a church or synagogue. You could say, I want to keep giving gifts to that, to that organization, but nobody else. Okay. This notice, and this is part of that. The suggested modifications don't have the witnesses in there. All right. Remember, the witnesses have to be disinterested. So we don't want the witnesses to be. Okay. And so here, this is actually extremely important, that we need to also specify in the modification that the agent can give gifts to himself or herself. All right. That needs to be in the modifications. There needs to be this ability for the agent to potentially make themselves a beneficiary of an account, be a joint account holder or a TOD, all these kinds of things. So or if it's if the agent's creating a trust, maybe they're a beneficiary of a trust. So you want to make sure that you say that the agent and the successor agents could potentially make gifts to themselves, because if you're going to do this, if you're giving that authority, you want to make sure that that they have that power. I mean, unless it's somebody who, you're paying somebody to be a power of attorney and to be an agent, and you don't want them to be the beneficiary of any account. Well, and that happens. So yes, then you leave this out. So there's also a provision in the law that says you have to say how the gifting is being done. All right. So in the suggested modifications, and I didn't include all of them, but there's a lot of detail. I just included the headings here that are in the suggested modifications. There's gifting, through bank transactions. All right, that's again TODs, joint accounts, whatever, to have a person named as a beneficiary of an account, or to potentially have power over that account. That's gifting. Gifting by changing beneficiaries or modifying life insurance. I think that's self-evident. Gifting by changing beneficiaries or modifying retirement accounts. All right. Again, hopefully you have on your life insurance and retirement accounts that you already have beneficiaries on there. And if you don't, I would highly recommend it and say, that's one of your first orders of business. And if you then become incapacitated, you're unable to do it. Suppose that happens, and then you need to change a beneficiary on any of those accounts. You want your agent to be able to handle it for you. Okay, if it needs to be done. So there we go. Life insurance, banking, life insurance, retirement accounts. Setting up a trust, okay, revocable, irrevocable, or joining and funding what's called a pooled trust. A pooled income trust is really something that it's a special kind of a trust set up for disabled people, and people do use it in connection with Medicaid to shelter income. All right, you put your money into one of these exempt pooled trusts, and it becomes exempt for Medicaid purposes. So that's something that a lot of people want to do. And they want their agent to be able to do it. So this is an important modification. All right, establishing, funding, revocable or irrevocable trust, or doing a pool trust. Okay, gifting by changing property interests or beneficiary statements. You might want to do a deed, or you might again, beneficiaries, being able to change beneficiaries. You want your agent to be able to do that. You can convey a specific piece of real property, or a cooperative apartment. Remember, this is all going into the modification section, and you really have this ability to do it any way that you want. So making loans and executing promissory notes, that becomes important in a Medicaid planning context. Sometimes we use promissory notes. Sometimes we use loans in order to do this planning to make sure people qualify. So that that's important. Make the ability to make loans to people can be an important family provision as well. Uh, and lastly, there's this control over digital assets. All right, and that's really in accordance with the law. The law changed a couple of years ago to allow for digital assets, so that allows your agent to access electronic accounts, Facebook, Google, whatever, but also any electronic assets that you might have, and it's not clear. I mean, bank accounts usually we already gave the banking power, so that's there. But like, all right, so what are digital assets? And I'm a little old, so I don't know exactly what all the kinds of digital assets are. But one thing that comes to mind is, suppose you have a monetized YouTube account, okay, a monetized or you have copyrighted material, or the new thing that people are selling, where those non-fungible tokens or something, those kinds of things. All right, those are digital assets. So if you have anything like that, I think that Bitcoin would also probably qualify under that. So control of your digital assets is important. It's something that would put in the modifications. It's in the suggested modifications. So something that you probably want to have. Okay, and like I said, these are the suggested modifications that are on the form from the Bar Association. I have not seen other commercial forms from like Bloomberg or something, so I don't know what their modifications are. But it's important, like if you engage an attorney to do your power of attorney, to do a power of attorney for you, that you look at these provisions and make sure that they're there, or if you don't want them, make sure that the attorney takes them out. They can be freely modified, okay? But it's very important that it reflects your wishes. This requirement of the two witnesses and all these kind of formal requirements indicate that in some ways the power of attorney is considered it is considered a testamentary substitute, meaning that it has as much power as a will, and it happens during your lifetime. So you want to give it the kind of seriousness that you would over a will, over dispositions in will. I see that there's a hand up. Can I? I could probably. You know what? Let me just go through this because we only got a couple more pages to go, and then we'll talk about. I'll be happy to answer all your questions. Okay, so I threw in this. This happens to be my revocation provision. I put this in all my powers of attorney, unless somebody doesn't want it. And so, okay, so this says this document revokes all statutory powers of attorney I previously executed. And I authorize my agent to deliver notice or record notice of same. So remember, the agent is responsible for giving notice to people that, hey, those old power of attorneys are all revoked. This is the new one. This is the one that you should pay attention to. This was the one that's valid. But then, so this is important also. However, the document does not revoke statutory or non-statutory powers given for a limited purpose. Okay, so in including here is bank powers of attorney. So if you gave, if the bank made you sign their form, this form should be good. This is a statutory power of attorney. The bank should not make you sign a separate form. If you have a valid statutory power of attorney, they're supposed to honor it. And I'm going to talk about that in a minute. But but if you have one, you had one that you did before, it's you don't want it to be revoked by this, and then the bank is going to make you sign another one. No. So you want to make sure that it's still valid, and that's basically what this provision says. If you give it to a bank or a securities account, or if you sold real property and you used a power of attorney, a lot of people do that. They give a limited power of attorney to their attorney or whoever's handling the closing, and then that gets recorded with the deed. All right, so that's recorded with the county. You don't want that to be revoked. I mean, yeah, it's a little bit of a question, but this is the real property. The real estate lawyers are very careful about this. So you want to make sure that power of attorney is still valid. And so that's all that, that's there. So this revocation provision to me is important. You may want to ask about, if you're doing one with an attorney, you're doing a power of attorney, you might want to ask, does it have this, does it have the revocation language in the modification? Because it's not in the main form. All right. The main form, it says it doesn't revoke. All right. It doesn't revoke any other statutes, any other powers of attorney. So you want it in the modifications, saying that it does, that I actually, don't want my old power of attorney to be valid. Okay. All right. So these are some of the provisions of the law. This is not where we're past the form now. So let's talk about the law a little bit, because these are important questions that come up, and these are modifications that came into the new law. So any person or institution can ask for the agent's certification as to a factual matter, and this is basically has really sort of been there for a while, where a bank or any financial institution can ask for an affidavit of full force and effect. All right, there's an affidavit. The agent gives an affidavit saying that this power of attorney is still good. The person is still alive. They haven't revoked it. All right, they haven't revoked this power of attorney. It's still good. So this is an agent making a representation, and third parties can rely on that. The bank can rely on it. So that's a factual matter. All right. So they also, a bank or a financial institution or a person can request an attorney's opinion letter. All right. They can, under the new law, they can make a request for an attorney's opinion letter regarding a matter of law. So if it's a question of legal, it's not going to be a factual question. Is the person still alive? Has there been a revocation? It's going to be, as to say the validity of this, or whether it confers a particular power. All right. So that's going to be, that can be supplied as well. Is attorneys can give you an opinion letter saying that yes, this power of attorney is valid to permit somebody to establish a trust, for example. That's just that's something there. And so, I expect that we will see some of this. I think that most likely what people are going to be looking for, what banks and financial institutions, they're going to be wanting to know whether an old form, a form done in like 2007, for example, whether that's still valid. So, I mean, that's just my personal opinion. That's what I think banks are mainly going to be asking about. Is they're going to be asking for an opinion letter saying that power of attorney is still valid. So I'm going to expect to see some requests like that. So under the new law, I mean, there were always sort of provisions where you could sue a bank or an institution if they didn't accept the power of attorney, for like no good reason. However, there were no teeth in the prior laws. So this law now makes it stronger. Okay, there's actual deadlines. The person, has to, or the bank, let's say the bank, must accept or reject the form within 10 days. All right, from the day you give it to them and say, here's the power of attorney, here's my power of attorney, they have 10 days to decide. All right. Once, if there's a response, like they ask for that affidavit, they ask for an attorney opinion letter. Once they receive those, they have another 7 days, okay, that they need to respond. And so there's actual penalties. There's, if there is an unreasonable failure to honor the power of attorney, then you can sue the bank. All right, you can sue them when For example, if they say you present a statutory form, and they say, no, we want our, we want our form, and you say, look, it's, it's fine, and then they ask for certifications or whatever, you could sue them. I mean, I know in most cases it's impractical, but in some cases it may be necessary, and now you can do it. And if you incur attorney's fees in suing somebody, you can recover those attorney's fees. So there really are, and so there's really some teeth in the new law, and we're very hopeful that I think, that things are going to be better, because this has been a problem. This has been a problem since 2010, when the form was substantially changed, with banks, delaying, with it, they're not, with rejecting powers of attorney. For a long time, they didn't even want it. They didn't even want to look at them half the time, and they would take forever. So we're hoping that that's all better under the new form, and that these are easier to use. Okay. So just a couple of other things, some other pieces on this. There is in the law, there's this ability for a person to sign at the direction of the principal. So if you have a principal who is physically unable to sign, and I've had to do this a number of times, people, especially for people with MS or ALS, in different cases, they're not they're mentally able to express everything to you, but they are not they're not physically able to put the pen to the paper, and now they can tell an individual to sign at their direction. All right. And it's a little, we used to do this, and we put affidavits in the file, regarding the circumstances of the signing. And I've never had one rejected, but it was never formally in the law. It's in the law of wills. You can actually execute a will like that if you're unable to physically sign it. But it was never actually applied to power of attorney. The law never applied, but now it does. So I think that's an advance for people. The most frequently asked question are prior forms. Are they still valid? And they are. Okay, if you did a form back in 2007 or earlier, back in the 90s, those forms, as long as they were validly executed, if they were properly done according to the laws of the time, those powers of attorney are still valid. Nobody can require you to do a new one. All right. If you want to do a new one, you say, oh, that's old, and I'd like to really, to specify the kinds of powers I want to grant, and I have this ability to do it through the modification section. I would do a new form, or suppose everybody's information has changed. You might want to do a new form for that, but you don't have to. All right. And if you can't, in some cases, people can't do a new form. So those old forms are still valid. All right, they're still valid. Also, if you did an out-of-state form, as long as it's validly executed in that state or other jurisdiction, then it will still be valid. Okay. And I have a little typo here, but anyway, it says a New York State form can also be executed, and it should say by an out-of-state resident. Okay, an out-of-state, a New York State, an out-of-state resident wants to present a New York form regarding, like, say, New York property, so they could use this. So an out-of-state person can execute they can execute the form in their state. All right, let's say it's Missouri. All right, they can execute the form in Missouri, but it has to be according to the laws of New York State. All right, it has to be validly executed according to those laws, meaning that you need the two witnesses and you need the notary. Okay. However, if you're doing a Missouri power of attorney, and I don't know anything about Missouri law, so don't hold me to this, but say Missouri does not require witnesses on their power of attorney. If you validly execute a Missouri power of attorney and you don't, and that doesn't need witnesses, well, then that form is also valid. That will be recognized in New York. Okay. And this is the information relating to how to how to get the form. There are some other, there are other outlets as well. There's legal forms, companies that will supply a power of attorney form. But the law, in the law, in section 1513, 5-1513 of General Obligations Law, it's there right in the book, obviously not easy to use. You'd have to, copy it out or something. The other thing is that the State Bar Association sells a form for $35, and they will give you those suggested modifications, just about the ones that I talked about today. Okay, now I'm ready for questions.
Okay, we have some questions.
Okay.
So the first one, you kind of just talked about it, but someone's asking that they know their old POA is still in force, but is there an advantage of doing it over with the new form?
Yeah, just to reflect, if you wanted to tailor the powers, like I said, using the modifications. So like I said, you don't have to, but nothing prevents you from doing a new form, throwing out the old one, and frankly, if you feel like it's going to be an easier sell to a bank, then fine, do a new form. I'm not going to. I mean, I know as an attorney, I'm not doing a great service here. I should be telling everybody, oh, you have to go get the new form. That way I could make some money. But really, you don't. You don't need a new form, and especially for people who cannot do a new form, those old forms are still valid.
If I prepare a POA for my daughter and she does not name me as an agent, may I be a witness/notary?
I'm not. You're
Appearing
doing a
for your daughter.
POA. Is it the mother is going to be the agent? It's
So she's
important
saying that she's not the agent. She's preparing the POA for her daughter, but she's not going to be an agent. Can she be a witness notary?
the daughter.
No,
Are
I
we
guess
asking if the daughter can act as witness?
No, it look, a mother is preparing, or a
Okay.
father, for a POA.
Okay. The
Yeah,
mother,
agent.
I would be very careful about that. Technically, a mother is not, would not necessarily be the first heir. There may be children, other children, grandchildren involved. But if the mother is the heir, is the natural heir of the property, and could be, then I think it's risky because there is some self-interest there. So I would be careful about that.
Can we expect forms to be revised?
I'm sorry, Melinda, I didn't catch that. Can you please repeat that question?
Can we expect the forms to be revised every 2 years?
I don't think that this I don't think that this statute will be changed for a number of years. I mean, this form has been in effect for the old form was in effect for 10 years, and people didn't like it from day one. So it was controversial. It was too complicated to use, and so really the 10 years that it's been around, 5 years have been trying to get it fixed. And I think that this form, the current form, is better. It represents an improvement over the old form, and I don't know that it would necessarily get changed. It's possible that there may be some technical changes down the pike when people find that there are issues with with some of the technicalities. Sometimes that gets changed, but I really don't expect that there will be significant changes. This form has been reviewed, it's been discussed, it's gone through the legislative process. It's been seen hundreds of people, and I think this is going to be around for a few years.
If gifts aren't in a will, Do they
Oh,
still have to be on the power of attorney?
all right. So gifts, you know, the will is clear, is clearly as a testamentary instrument, only becomes effective after your death. Uh, so on the other hand, a power of attorney is effective during lifetime and ends upon death. So you want, and it really depends on what you want it to do. Okay, if the intent is for your agent during your lifetime to do some estate planning, perhaps establish a trust, or to do so, if you want to give the agent that ability, then you have to have that gift giving ability in there. You could do it. I mean, when you put it in, you could put it in your will as well. But this, we're talking about, what's immediate, what's needed in terms of your day-to-day life. Okay, so that, I think that's my answer on that.
Okay. Are these suggested modifications in the new power of attorney, or do you have to add them in?
They have to be added in. These are suggested modifications. Like I said, and they come from the State Bar Association. The State Bar Association, if you order the form from the State Bar Association, they will give you the form, and they will give you a couple of pages of modifications, which are the ones that I just went through. Okay. Other companies may have different modifications, although I suspect they're going to use most of these. So modifications are a little bit iffy, and that's one of the things, I have to say that I think you really need, you really kind of need an attorney. If you're going to have modifications in there, you probably want legal counsel in terms of assisting you with this form. I try to usually stay away from that, but I'm gonna say it. It's like, I don't see how these modifications could be properly implemented without legal counsel. If you just want to use the standard form, that's great. You could do that. I don't think you need a lawyer. All right, but modifications can get these modifications get a little complicated.
If a third party is indemnified, the POA is revoked, what is the benefit of revocation?
Well, the indemnification is when you present it. You're basically indemnifying a third party. But if it's been revoked, and and you're presenting a revoked power of attorney to a bank, for example, they could turn around. They can turn around and sue you. So that's the issue with revocation. Is you want to make sure that the proper form is adjusted, and that there's not an agent who's running around presenting a revoked power of attorney. So that gets a little bit messy. I'm not going to really address all the the ramifications of that, but that's but you can. The idea is that when you put a new power of attorney in effect, under the revocation provisions, you have to know, you're revoking your prior ones. You have to notify people. You got to notify people who relied upon that form.
Are there other states that do not accept other states properly exercising powers of attorney?
I'm not really aware of any. I think most states do, but I really couldn't tell you about all 50 states. Most states will, though. Most states accept an out-of-state power of attorney.
Does an agent's signature need to be notarized?
Yes.
In addition to the existing power of attorney and living will, will the will of the principal be valid and enough for the transfer of co-op property at the time of death, and or will the existing power of attorney be okay?
Okay, so this goes back to what I said before. Powers of attorney, lifetime. They're for your lifetime. You use them. Your agent can act during your lifetime. when someone dies, that power, that grant of authority is over. All right. Powers of attorneys should never be used after death. Okay. After death, that's when a will would be necessary. If you needed to transfer property, then you would need to have a probate of a will. And if it is specified in your will, you know, it will be there. Right? It'll happen. It's just that you would then need a probate process after death. Power of attorney, again, lifetime. All right, but it's over. It's done when it's done after death.
And the final question, I think, is asking when an agent on a New York State power of attorney, will the power of attorney be valid if that agent goes to another
state?
Yeah.
Yeah, it should be valid. It should be recognized in another state.
Thank you very much. That was a lot, and it was wonderful information. That was really great.
Okay, well,
Melinda, I'm just going to jump in. There was one question.
Oh, okay.
I'm not sure if we've answered. Do the protections of the new law apply to the old form, or must I execute the new form to get the new protections?
And the answer is that the old forms are covered under the new law. So that whole thing, that whole procedure for acceptance or rejection, the penalties for unreasonable rejection of the form, those are all going to apply to old powers of attorney as well as new ones.
Thank you. And thank you everyone for watching. The PowerPoint and this presentation should be on the Senior Law Day website by Friday. And I think Bruce has a few closing remarks, everyone.
Thank you, Melinda and Deep. I just wanted to take a moment to acknowledge our sponsors for this program, and they've been extremely central since we've gone to virtual programs when the pandemic started. I also just wanted to mention, well, I'm going to do two more things. I'm going to be sharing a poll by which you can give us some quick feedback. And then while I'm doing that, I wanted to just point out that we do have another webinar coming up in 3 weeks. If you have anyone or responsible for anyone with special needs or disabilities, then we have a special program on that on July 21st.
Okay, thank you, everyone.
Okay, thanks very much, everyone, and have a great day.